Okay, while waiting for others to join. Well, all right, yeah. Today we will, I will share, about insider trading. Okay, not everything about insider trading, but generally, okay, the laws and principles are regarding insider trading. Okay, so next slide. Okay, what is insider trading? Okay, anyone wanted to try answer? Okay, for those who have no idea what is insider trading or have never heard, okay, I found a very layman video, okay, that will hopefully will explain, okay, what is insider trading. Okay, this is a very short clip. I think it's about 3 minutes. Okay, let's have a look. Okay, and then I will explain more after the clip. Okay, after the video. Yeah. Mike?
Okay, give me a moment.
Okay.
Legal insider trading. In this video, we will discuss illegal insider trading. We will discuss two situations. First, where a company insider trades stocks based on important non-public information. And second, where insiders provide important private information to people outside the company. So let's say we're at a company's important business meeting on March 30th at 9 in the morning. Attending this meeting is the company's chief executive officer and also the company's chief engineer. We would call the CEO and the chief engineer insiders. They are insiders based on their status as executives of the company. The chief engineer has bad news. The company's new product does not work. Because the product is defective, it cannot be sold. The CEO is sure that when this information is released, the company's stock price will fall. But as of March 30th, the stock market is unaware of the important bad news. The CEO realizes that she can make money on the stock market because she knows in advance that the stock price will go down. After the meeting on March 30th, the CEO gives instructions to short her company's stock. On March 31st, the company reports that its new product cannot be sold. Everyone now knows the company's new product is a failure. Now the market is aware of this important bad news. As expected, the company's stock price falls. But the CEO knew the stock price would fall, and she makes a lot of money off it. The CEO committed illegal insider trading because she traded stocks based on important non-public information. Let's say on March 30th, the CEO also called a friend at a different company. Her friend pays her to disclose the important non-public information. The CEO alerts her friend that the company will be presenting bad news tomorrow. The insider who provides the information is a tipper, and the friend who receives the information is a tippee. The tippee traded stocks based on the important non-public information that was disclosed by the CEO. Both the tipper and the tippee have violated illegal insider trading laws. The tipper received a benefit, and the tippee knew the tipper was not supposed to provide the secret information. If you'd like to discuss illegal insider trading or any other matter related to U.S. law, stop by the message board.
So as we know, okay, the video shows us that there are two types of insider trading. Okay, the first one is where the insider, he himself trades. Okay, trades means you either buy, next slide. Okay, you either buy or dispose, okay, or enter into an agreement. Okay, to buy shares. All right, and the second, okay, is the where the situation where he himself doesn't buy, okay, he himself doesn't trade, but he releases that information to a third party who he knows that that third party will rely on that information to trade. It means he doesn't need to trade, but the third party trades, okay, on the securities based on the information given by him. So there are two types of insider trading. Okay, so it's an offense. Yes, okay, it's an offense under Section 188 of the Capital Market and Services Act, CMSA. Okay, we will refer a lot of CMSA in the following slides. Okay, because this is the main legislations that cover or governs, okay, insider trading activities and regulations. All right, next slide. Okay, why is insider trading considered a serious offense? Okay, SCA, the regulating body, Securities Commission of Malaysia, considers this is a very serious offense, okay, for the following reason. Because one, it involves misappropriation and taking advantage of inside information, okay, which should rightly belong to the company. Okay, it should be PNC, it should be kept with the company. The insider unjustly enriched himself, okay, to the detriment of others based on the information. And it is unfair to the other market participants, I mean investors, okay, who are not in the position to gain access, okay, to similar information. And insider trading injures the overall market condition, market confidence, okay, of our stock market. Okay, so these are the reasons, okay, why it is regarded as a serious offense. Next slide. Oh yeah, okay. Before this, okay, let's just go through one of another video. I would like to just showcase another video regarding as a famous examples, okay? Famous Mike. Okay, it's also a short clip.
In 2015, Martha Stewart's main brand name sold for just a fraction of its original worth. Many have attributed the devaluation to Stewart's widely reported legal troubles concerning insider trading. In 2004, she was sent to prison for 5 months for related charges. So what did Martha Stewart do wrong? What exactly is insider trading? Well, in 2001, Stewart allegedly obtained non-public knowledge that a particular stock investment was about to lose money, and she dumped the stock early. This kind of knowledge is also known as insider information. It is only available to high-level executives or major shareholders in a company known as corporate insiders. While corporate insiders are allowed to trade any stocks, they must register potentially conflicting trades with the Securities and Exchange Commission. It's illegal to use insider information to profit from potential stock changes. This disadvantages public stockholders and betrays investor trust, which is vital to the health of the stock market. However, just because insider trading is illegal doesn't mean people don't still do it. There are usually huge amounts of money on the line, and the risk of getting caught is often very low. A study cited by the New York Times in 2014 claims that a quarter of all public company deals involve some kind of insider knowledge. The SEC has limited resources, so they only pursue the largest and the most legally viable cases. They can also be slow to respond to reports of illegal activity, taking more than 2 years on average to announce litigation. Additionally, many criminal charges aren't legally viable because the divide between intentional insider trading and pure coincidence is often murky. Many traders simply claim they got lucky to have sold off their stock before it devalued. This gray area is one of the reasons that Martha Stewart was never actually convicted of insider trading itself. She went to prison because she was caught lying to federal investigators about her role in the scandal. The SEC does its best to monitor suspicious trades. They act on tips or complaints, and they have market surveillance tools that track when large purchases or sales of stock happen. If they do make a conviction, any insider tip givers or tip receivers can get 25 years in prison. Individuals may also be fined up to $5 million, and companies may be fined up to $25 million. The largest aggregate fine for insider trading in history happened in 2014, where multiple guilty parties working with a hedge fund group faced penalties totaling $1.8 billion. Insider trading is one of the most common white-collar crimes, perhaps because it often seems to be victimless. But a prominent U.S. attorney involved in many Wall Street executive prosecutions says nothing could be further from the truth. The market is a victim. And the loss of trust in the public stock market will hurt the entire country's economy. Ever wondered what it would take to crash the stock market? We've got a video on some of the worst market crashes in history.
A crash represents a steep, sudden decline in the value of market prices, and it can often lead to an economic depression.
Thanks to everyone for watching TestTube News. Please subscribe to get new videos every day.
Okay, so we see that that's of course the situation in US. Okay, but as we'll go along, you'll see the Malaysia's standard, the threshold to establish this offense of insider trading is much lower. Okay, the threshold has made lower so that the prosecution would be more successful. Okay, if you compare with Australia or other jurisdictions, it's harder because of the threshold being set very high. Okay, they need to fulfill certain requirements that is not in our CMSA. Okay, so we will see the relevant provisions here of the CMSA. What does it say? Okay, so section 188 is the main section that usually insider trading will be charged. Okay, that's the provision where you are not supposed to trade, which is in section 1882. Okay, you are not supposed to acquire, dispose, buy or sell or procure. Okay, that means not yet sell, not yet buy, but procure or enter into any agreement. Okay, these all are prohibited. Okay, and section 1883, as I explained just now in the short video, okay, is based on tips. That means the insider himself does not trade, but because of his information, he tips, okay, he give the tips to a third party, and that third party does all this, okay, acquire, dispose, procure, or enter into the agreement. So that insider will also be liable, can also be liable, okay? So it's either subsection 2 or subsection 3, okay, usually the offense, okay? But we will see most of the case will be on subsection 2. That means the insider himself trades. Okay, next slide. Okay, so what are the elements required to establish insider trading? Okay, the trading was effected by an insider. First, there must be an insider. Okay, pursuant to insider's knowledge. Okay, is the insider and insider's knowledge, okay, of the non-public material. Okay, not only any information, but must be material, must be non-public, okay, regarding the company and the effect of that information. Okay, that means how material is the information when it is made available to the public, that it will affect the price or value of the securities of the company. So these are the things that elements, if one is to be charged, okay, or SC to bring action, these are the things that the SC has to prove, okay, on the part of the insider. Okay, let's go through one by one, okay, of the elements. Next slide. Okay, insider. Okay, who is an insider? So it's defined under section 188 sub 1 of the CMSA as a person who possesses material non-public information and who knows or ought to know that the information is not generally available. One who is likely to be in the know about significant corporate matters. Okay, historically, okay, the requirement for insider, it must be based on the fiduciary duty. That means you must also establish the insider is either an employee inside the company or director or, okay, someone inside the company. But now the CMSA has that's why I say it's lower the threshold. The insider not necessarily must be employee of the company. Okay, it can be outsider. Okay, it can be someone outside. Okay, but as long as he knows of the information, he possesses the information, and he knows the information is not generally available, then that person will be an insider. Okay, you see how the threshold is lower now. Okay, so under CMSA, as we know, previously it was known as securities. Okay, before, okay, in 1983, Securities Industry Act, but this was later repealed, okay, and now replaced by CMSA. Under Section 89 of the old Act, SIA we call that, the offender must be an officer, agent, or employee of the company or of the stock exchange. Then he had made improper use of the confidential information. Okay, that was the old provision. Okay, next slide. Okay, so insider, establish the insider, establish knowledge, okay, or possess the information. So what's the standard of possess? Okay, the court will use what standard is on the back. To use balance, that means on the both side story, which one is more probable? Okay, so that's why we call balance of probabilities. Both sides will have their defense and proof, right? So balance, that means court whose one is more probable, whose version. Okay, so court will consider, okay, in deciding whether this person, this insider, does possess the knowledge. These are the factors that court will determine, okay, will take into consideration his access to the information, okay, and then of course his relationship, okay, tipper and TP, and the timing, okay, when he got the information and when he disposed, very near or take a long time, a long gap, okay, and the timing of the trades, and then a pattern of the trades, okay. So some like as we see in the cases, okay, that we'll discuss later, some of the trades, that means he got many other shares, but he only disposed of that share, that particular share. Okay, he got ABCD share, but he only disposed of A share. Why? So that kind of pattern. Okay, so and attempts to conceal the trades or the relationship between the tipper and the TP. Okay, that will also plays a part. Okay, there will be relevant factor, like the court will see whether there is a possession of knowledge or not, possession of the information or not. Okay, if you can't prove that he possessed that knowledge, then the element is not fulfilled. Then you cannot establish that offense. Okay, so next slide. Okay, in this Sri Santan's case, Securities Commission against Sri Santan's case, this Sri Santan, okay, is a partner, okay, in one of the legal firm, Kadir Andri, okay, a corporate lawyer, okay, and experienced corporate lawyer. So in that case, court found that the SC has shown that the defendant obtained the information on the proposal for PKNS to privatize listed subsidiary from personnel of CIMB. What happened in this case is that he is a corporate lawyer. Okay, so CIMB instructed, okay, Kadir Andri to handle this case. Okay, to handle, there's a plan for privatization by PKNS of privatization of its subsidiary. So PKNS has only one subsidiary. Okay, although the identity of that subsidiary name was not revealed during the discussion, okay, but because based on information that PKNS has only one subsidiary, so he knows of that plan. Okay, and at the same time, he also holds the share, okay, of that subsidiary. Okay, the subsidiary is WHB, okay, Worldwide Holding Berhad. It's a subsidiary of PKNS. So right after, I mean, not long, okay, about the same time, there's a meeting, okay, between this defendant and also the representative of the CIMB, and then they draft a privatization plan, discuss with him, and then the CIMB investment go and present that to the Menteri Besar, because PKNS is under the Menteri Besar Selangor, right? So there was, in between, there was phone calls, okay, this somewhere in June 2006. Okay, and at about the same time also, actually the first transaction that he bought the shares is on 7 June. Okay, see the phone calls was 6 June to 8 June. 7 June, then he started acquiring the share of WHB, the subsidiary. Okay, and then these are the facts, okay, inside the case. When you read the case in full, these are the evidence, okay, that it shows they do possess information. Okay, this defendant got the information. He knows of that privatization plan. Okay, so the privatization plan is held by the court here to be a material information. That's the information, okay, and that's a material information because if once it's made public, it will influence, okay, the investors to buy or to sell, okay, their shares. So once they got this instruction, okay, from CIMB, the defendants instructed, okay, as junior lawyer who worked with him to prepare a draft joint venture agreement. Okay, so apart from that, okay, these defendants also instructed his secretary or his assistant to do a search Selangor Corporation Enactment, okay, which is the regulation that regulates PKNS, okay, because PKNS is incorporated under Selangor Corporation Enactment. Okay, so these facts, okay, on the balance of probabilities, it shows that the defendant has the information, okay, possessed of the information. So cases shows that there's no need to direct, okay, there's no need to show direct evidence, okay. This is a voice on another case, Suruhanjaya Security Malaysia against Chan Soon Huat. Okay, these are supports that the principle that you no need to show direct, because if you show direct evidence, you won't be able to show direct evidence. Next slide. Okay, in SC against Chan Soon Huat, okay, this is the first case in 2017, okay, reported in 2018, where the court, this is the first civil proceedings brought by SC against for insider trading. Yeah, so the court used the factors discussed in the Chan Soon Huat's case. Okay, the factors are, okay, insiders trading, insiders access to information. Okay, just now we discussed these factors. Okay, it was discussed in this Chan Soon Huat's case. Okay, so circumstantial evidence pointed that the insider does have access to the information. Okay, and the relationship between tipper and TP. Okay, what happened in this Chan Soon Huat case is another story. It's a director, okay, of this company called WCT. Okay, and then this WCT got entered into a project, okay, somewhere in Dubai to build a race course, but it was halfway cancelled. Okay, the terminated, that means the agreement, but it was not made public yet. Okay, this Chan Soon Huat was already resigned, although he's no longer a director at that time, but he maintained a close relationship with other directors in the company. So based on balance of probabilities, okay, because of the close relationship, okay, between the tipper and the TP, so this insider shown that to have that information, okay, because even after he has resigned, he still can go in and out, okay, free access to the company, and still visits the company regularly. Okay? And there are also phone calls, okay, made between this insider and the tipper. Okay, I mean other directors in the company. So these are the factors that show, okay, the unnaturally timely disposal. In Chan Soon Huat case, okay, the termination was on 29 December 2008. Okay, and 30th, just one day after, 30th December, this defendant, okay, this Chan Soon Huat, go and dispose his shares. Okay, And on the 6th January, that means about 1 week later, only made the announcement. So in between, okay, within 4-5 days, he sell off his shares of that company. Okay, so that's why the court said the unnaturally timely cannot be so coincidence. Okay, just 1 day after the information, he got news of the termination of the agreement, he go and sell his shares already. Okay, next slide. Okay, the nature of the impugned disposal. Okay, he has been holding the shares for 4 years. Suddenly disposed them within 4 days, right after the announcement. So that's this nature cannot be a coincidence. Okay, so they disposed, the insider only disposed his WCT shares, and he did not dispose his other shares. Why? This explains that it cannot be coincident. Okay, and the disposal pattern. Okay, the disposal made 1 day after the termination of the agreement, okay, is the single largest disposal, okay, since 2005. Okay, that disposal, okay, is about half, okay, 46%, half of the volume traded on that shares. Okay, on that day, on the 30th December, okay, the day that he disposed. So all these circumstances that show that it cannot be coincidence. Okay, and his evidence when in court, cross-examination, he say why sudden disposal. He say he need the money to buy shop. Because he got gambling habit, he needs to settle gambling debt. But no evidence. There's no evidence to show. Okay, no one come to support that he needs to buy. He really needs to buy a shop, or because he really got this gambling habit. Okay, next slide. Okay, where the insider, after he got the money, where he placed that money, where he said he want to buy a shop, right? But evidence shows that none of the money he used was used to buy shop, buy any property. None of the money, the proceeds of the sale, was used to settle the gambling debt. Okay, so instead, what he put into another fixed deposit account at CIMB. Okay, 85% of that sales proceed, and he also deposited back into his trading account. Okay, and also he deposited to his daughter's account. None of the money go to buy property, as he has testified before. Okay, okay. So these are also circumstances that show that he has that possession. Okay, and yeah, he has that possession. Okay, so time when the public knew of the information. Okay, there must be a gap. Okay, before the information was made public. All right, next slide. Next slide. Okay, so the information for purpose, okay, of establishing this offense, as I say, not any information. Okay, so information must fall under the categories under section 183. Okay, 183 of the CMSA does list down what kind of information. Okay, so these are the cases. Okay, we pick some of the cases that held what kind of information that the court held that it is material. Okay, so for Sri Santan's case, as we discussed just now, it was the privatization plan by PKNS of its subsidiary. It was held to be material. Yes. Okay. So in the case of Chin Seng Huat, okay, another case by 1999, it is in the form of information accounts of subsidiaries, okay, and associates to the listed company. That one was also held to be material. Okay, so this case also Lau Chi Huat, okay, and monetary. This one Singapore case, okay, the loss forecast and the possible impairment of charge. That was also held to be material. Okay. And also this Chan Soo Huat, because of the cancellation of the agreement, okay, was held to be material. Okay, so it must fulfill, okay, not all information. Okay, that information must be material to be an offense. Okay, Next slide. Okay, another case, another element is that not only you must establish he possessed the information, you must establish that information is not generally available. So in order for the information to be generally available, it must have been made known in a manner that would bring to the attention of the reasonable investors who invest in share. Okay, and a reasonable period must elapse. Okay, you can't be, let's say you make the announcement 10 a.m. sharp. 10:01 a.m. then you quickly go and dispose your share. Okay, so you must allow a reasonable time for people to digest, to really make, make the information generally available. Okay, so there was what was held in Sri Santans. Okay, you must usually it's between 1 day, 2 days. Okay, depends on the complexity of the news. Okay, simple news, 1 day. Okay, complex news, maybe 2 days. Okay, 1 to 2 days lah. Okay, to people to digest, okay, the news and to make decision. Okay, they would either buy or dispose of their shares. Okay, and see, it must be bring to the attention of reasonable investors. In Sri Santan's case, okay, he tried to defend that at the time he buy the shares, the news remiser already broke remiser. But the court held that, hello, remiser are not reasonable investors. Remiser are brokers. Okay, so they are not investors. They don't fulfill that requirement. Okay, so it must be investors. Okay, merchant bankers. Merchant bankers are not investors. Okay, they are financiers. Right. So in the case, the information that PKNS was proposing to undertake the privatization, okay, was on 19 August when it was first published in the Star. That point only is made generally available. Okay, by the time he already bought all the shares okay, he already traded in the shares. So for information to be generally available, it has to be also supported that after the publication, what happened? Did the share price go up or go down? Okay. So in the Sri Santan's case, after the privatization plan was published in the Star on 19 August, the share price did went up. Okay. To the highest, okay, from 2.59 to $3 something. Okay, so you see that's the materiality of that. Okay, not only available but material. Next slide. Okay, to establish this offense, the SC not only to prove that the information is generally available, but he has also to prove that the defendant at the time he traded in the shares, he has knowledge that the information is not generally available. Two things, two different things. SC has to prove that the information is generally available and that the defendant knows at that time that the information is not generally available. Okay, so in Sri Santan's case, the court observed that the accused has knowledge, okay, that the information is not generally available at the time when he traded in the shares. Okay, because one, the most obvious reason is he is a corporate lawyer. He's an experienced corporate lawyer, not a freshie. Okay, he's supposed to know that information communicated to him, okay, and the corporate proposal, okay, we have not yet been announced, would be information that was not generally available. Okay, now and then when he opened the file, okay, to prepare the draft JV agreement, the assignment he put a code name, Project State. Okay, why he put a code name there? Okay, when a person knows that he's a code name, okay, that project must assign a code name there. Okay, he will know that the information inside there must be PMC. Okay, would be something not yet made public one. Okay, that's why he put a code. Okay, otherwise you don't need to put a code. Okay, you can just put A company against B company, right? Okay, and then the JV agreement, when it was drafted, initially it was drafted with the names of the parties, okay, by his junior lawyer. So when he proves that agreement, he asked the junior lawyer, please remove the names of the parties. Why? That he knows that because that shows that there was a balance of probabilities that show that he know that the information is not yet available. That's why he asked the junior lawyer to remove the names. Okay. Next slide. So all this just now, all that shows that the defendant, okay, knows that at that time is not generally available. Okay, and then material. Okay, the information not only made general but also material. If the information becomes public, it doesn't affect at all the shares. I mean the price of share. Then you cannot say that it's material. Okay, the information once become public would influence a reasonable investor to buy or sell the shares, then only you can call that material. Okay, under section 185 of the CMSA. So in that case, Sri Santan's case, okay, the information was material because, as I said, after publication in the Star in August, there was a sharp increase. Okay, so that shows that it was material. And a reasonable investor would expect PKNS to offer a premium price, okay, as incentive, because the shareholder has to vote in favor of the privatization. Okay, so that shows that there's a facts that shows the materiality of the information. Next slide. Next slide. Okay, defenses usually then we will, these are the, okay, some of the defenses that usually will be raised, okay, by the defendant. One is that he's not insider, okay. You see the elements are, as long as you don't prove any of the elements, okay, that will be a defense. Okay, insider, you have to prove that you are not insider, okay. He does not possess the information, okay. The information that accused possess is generally available. By the time you trade, actually it's already generally available, then there will be a good defense. But then we have to prove. Okay? In this Sri Santan's case, that the accused, his defense is that by the time he actually obtained this news when he buy, not from CIMB, but it's from a investment report by CIMB, not during the meeting, not because of the meeting. Okay, but so his defense is that by that time the information is already made public. Okay, but when the court peruse, okay, see what is the report about, the court did not agree because inside the report it doesn't mention anything about privatization. Okay, so CIMB does have an investment report, okay, before the meeting, the privatization plan, but it's not material. Okay, all right, next slide. In that case also, the accused argued that the intent to use the inside information must also be an element. Not only the material, not only the possessed knowledge, but you have to prove intent to use that information. Okay, but the court disagreed. Okay, prosecution does not need to prove intent to use inside information. Okay, as I said, see how Malaysia cases have been, the threshold has been brought lower. In Australia, yes, you still have to prove intent to use inside information. Okay, so the trading prohibition takes effect once a person comes to a knowledge, have knowledge, and then trade. Actus reus and the mens rea there, then there's offense already. Okay. Okay, next slide. Okay, in that case also, the accused raised that the SC has wide power to do certain things, right? That will help in the case, but it has failed to do so. Okay, it has failed to adduce documents and other evidence that it was empowered to inspect. So basically what the defendants raised is that adverse inference, okay, against the SC under section 114G of the Evidence Act. Okay, so Evidence Act Section 114G is not simply used. Okay, you can't simply use 114G. Adverse inference, you only raise that when you have the document, but you withhold from producing it. Not when you have a duty, but you did not do it. That's not adverse inference. Okay, in this case, SC does not have the document. Okay, so you can't say that that's in adverse inference. Okay, next slide. So the defense also cannot use. So another thing is that, okay, the accused also raised that the proceedings have been improperly commenced by the SC because only the AG can bring action for offense, okay, alleged to have committed. Okay, this is in under Article 145 sub 3 of the Federal Constitution. Well, and Article 145 sub 3 does say, okay, for any offense, okay, an AG may bring any action, but for an offense, okay. But here, Section 90 of it was held that, okay, because at that time it was brought under this old act, okay, SIA. It was not unconstitutional, okay, to the extent that it purported to empower the SC to bring proceedings against any person. Okay, AG can empower the Securities Commission to bring either criminal action or civil action. Okay, next slide. Okay, so institution of proceedings. Okay, so there's just now I've said, okay, it can be a criminal proceeding, can be a civil proceeding. Okay, so sorry, it should be Article 145, yeah, not section. Article 145, sub 3 of the Federal Constitution says that the AG shall have the power exercisable at his discretion to institute, conduct, or discontinue any proceedings for an offense other than the proceedings before a Sharia court, native court, or courts martial. Okay, but under this, AG can empower the SC to bring action for insider tradings or for offenses under the CMSA. Okay, for criminal penalty under Section 188 sub 4 of the CMSA, the once convicted, okay, if liable and convicted, it can be imprisonment up to 10 years and a fine not less than 1 million. Okay, for next slide, civil proceedings. Okay, and penalties. Section 90 sub 1A, okay, now under CMSA is Section 200. Okay, it does provide for civil remedies by the SC against persons, okay, who contravene the provisions. So apart from criminal, okay, the SC can also institute civil proceedings if, okay, it is in the public interest to do so. Okay, it can bring these proceedings. It doesn't matter whether that person already been charged under criminal, okay, simultaneous or what, can still bring. Okay, Section 200 sub 1 of the CMSA. Then SC can recover, okay, if civil proceedings, it can recover 3 times the amount of gain made by the insider, okay, and claim civil penalty, either pay the 3 times, okay, of gain or fine, okay, not exceeding 1 million. That was held in Chan Soon Huat's case. Okay, and this was supported. Okay, the power of the SC to bring civil proceedings was actually supported by a bill. Okay, Hansard on 17 December 1997. Then there's a bill to introduce Section 90 of the Act, the old Act. Okay, right. And then you can request, okay, under civil penalty, not only pay the 3 times and the fine, you can also request for removal of the insider. If he's a director of a public company, then the court can also order that he will be barred from holding his directorship. That means he cannot be a director of that company for a number of years, okay, 3 years or 5 years, okay, up to the court. Okay, and also the court can also order that the insider cannot trade in any securities for a number of years, a period of years. Okay, that's what happened in Chan Soon Huat also and Sri Santan's case. Right, next slide. Okay, just go through some reports, okay, of the criminal prosecution for insider trading in 2021, okay, this year alone. I've just picked some, okay, actually there are quite a number, okay. Dato Lim Kim Chuan against two others, okay, they were charged in Sessions Court, okay, in 2015, and then possession for inside information, okay, then they were acquitted and discharged, and so the prosecution appealed, okay, appealed and allowed, prosecution allowed. But subsequently, they entered the consent judgment. Okay, SC is empowered to enter consent judgment, okay, if it brings criminal proceedings with the consent of the AG. Okay, can enter consent judgment on 28 April 2021. So therefore, the criminal charge is discontinued. Okay, Yu Lai Peng, another case, okay, for contravention of the section 188, okay, of the CMSA. So he also entered into consent judgment, okay, in a civil courts action, and then the charges withdrawn, okay, in July 2021. And then next, Ramesh, okay, Analalaki Rajaratnam, charged also for insider trading, section 188 sub 2, charged in 2015, okay, 3 counts, found guilty. He appealed to court, High Court, on May this year, and allowed, okay, allowed. So the prosecution appealed, okay, I think it's now still pending. And then the Sri Santans, okay, this Sri Santans case is not the same as that, okay, it is a different person, it's the same person, okay, but different case, yeah. But this one is charged with 7 counts of insider trading of a different company. See, so this one Sri Santans looks like a professional, okay, really handling insider trade, I mean, corporate exercises cases, yeah. So he was also charged, okay, for 3 accounts of insider trading, but in that case, he was acquitted January 2021 by SC, acquitted, and then the SC appealed, okay, to High Court on January 2021. I don't have any outcome yet, okay. Actually, this one cases you can view under the SC website. Okay, they had reports there, okay, a listing of all the cases there, what are the brief facts and what are the outcome of cases. But from the trends here, you see the prosecution, okay, quite a mix, okay, quite a mix. Okay, some cases that they managed to establish, okay, but like this Ramesh and this Sri Santans, they failed to publish the, establish the elements. Okay, so really it depends on the facts of each case. Okay, yeah, especially to that covers, okay, the materiality and the generally available, that part. Okay, I think that's all. My next slide, okay, just a takeaway. Okay, so for takeaway, let's say if you come into possession of an insight for information, what should you do? Okay, first, of course, you're not supposed to trade. Okay, do not trade securities based on the inside information. Okay, don't simply trade. And then do not communicate, okay, such information to anyone, including your spouse, your relative, friends, business associates. Okay, next. Okay, and a person can only use that inside information when the information has been made public through a proper channel, usually published in the report, okay, and sufficient time. As I've said just now, you cannot be, 10 a.m., okay, you announce, and then 10:01, then you quickly go and buy or dispose. You don't allow, you have not yet allowed a sufficient time. At least you see typically 24 hours, 1 day for simple information, or at least 2 days if the news is more complex. Okay, so do not rush. Advisors, lawyers, this one for, okay, lawyers, especially here. okay, valuers, consultants who come into possession of inside information, okay, when you are carrying out your work, okay, you're reminded that not to share the inside information with anyone, including those who are not involved in that work. Okay, so when you're caught, remember, okay, not only your professional career will be affected, okay, you will be liable, you can also be liable for criminal charge. Okay, so that's why I say it's a serious offense. All right, okay, and I think that's all, right? Yeah, thank you for attending. Is there any questions? Any questions? Any comments? If not, okay, I thank you for all attending. Okay, if you later have any questions, you feel free to ask me. Okay, I hope you find the session useful and beneficial. Okay, and if you need the slides, I can always ask. I can share the slides. Okay. Okay, if there's nothing else, then yeah, I'll see you again. Thank you.